a lot about the insurance angle of all these questions that I've been talking about. And with that, I'm going to turn it over to Ed C.
All right, thank you, Greg. I'm going to talk about nonprofit corporations and how the COVID-19 pandemic has affected nonprofits. A nonprofit can include an educational institution, a charitable organization, trade associations, or homeowners associations. But if you're formed as a nonprofit in Michigan, you are subject to the requirements of the Michigan Nonprofit Corporation Act. In fact, you're subject to 4 governing documents. The first one is the Michigan Nonprofit Corporation Act, which is the most important one. The second is your Articles of Incorporation. The third is your bylaws. And the fourth is any policies that you have adopted. So the first question I want to talk about, what are the consequences under Michigan law for not having held your annual member meeting? Now, because of the pandemic, and because of the CDC guidelines and Governor Whitmer's executive orders, we can't have meetings. So most nonprofits have not had their annual meeting. But Michigan law provides that a nonprofit corporation shall hold an annual meeting each year to elect directors and conduct any other business that they want to conduct, unless the members act by written consent or by ballot. And I'm going to talk about written consent and ballot a little later. That's an exception to the annual meeting requirement. In addition to that, most nonprofit bylaws will say that the organization has to have an annual meeting. So if the annual meeting was not held, Michigan law provides that the meeting must be held. In fact, the board shall cause the meeting to be held within 90 days after the date that it was supposed to be held. And if it isn't held within 15 months after the date of the last annual meeting, that the circuit court can order that a meeting can be held. So Michigan has a very strong law requiring all nonprofits to have an annual member meeting. The law also says that failure to hold an annual meeting does not affect otherwise valid corporate acts of the nonprofit or give cause to dissolve the corporation. So those are 2 good things. Now, what are the exceptions to having an annual meeting? There's really 3 alternatives to not having an annual meeting. And the first is that the members can act by conference call or video call. And that's become more and more common. Everybody's acting by video call, by Zoom, and that requirement will satisfy the annual meeting requirement unless your bylaws or articles do not allow you to do that. You can have that by video call or conference call, regardless of whether that's in your bylaws or articles. Under old Michigan law, you had to have that in your articles or bylaws. Under new law, you can automatically do that unless the bylaws or articles prohibit that. Okay, members can also act by written consent. By written consent, it means the organization sends them out a form, which we call a consent, which has a choice on it. And the member indicates their consent to that by signing that and sends it back. And that can be member action instead of an annual meeting. Now, the law says that has to be unanimous by all members unless the organization has amended their bylaws or their articles to act by majority. So if you amended your articles, you can get action by a majority of members writing back to the organization. The third way to satisfy the annual meeting requirement without a meeting is what's known as by ballot voting. And ballot voting is one of the best things that's come to membership organization in years. This was made legal in Michigan about 5 years ago. And I'm going to talk more about ballot voting later in the presentation, but just suffice to say now that under ballot voting, if the organization has adopted it in their articles or bylaws, they can send a ballot out to all members. The members check the little box depending on how they want to vote and send it back, that can be a valid member meeting. So the moral of the story with annual meetings is that Michigan law requires an annual meeting and everyone should have one every year. And if you haven't had one for this year, which you probably haven't, that you should schedule one as soon as possible. Okay, since we can't have meetings, many organizations are doing remote meetings. So I want to talk to you for a second about how to properly conduct a remote meeting. First of all, as I said earlier, any nonprofit can do it unless it's prohibited by the articles or bylaws. Notice of the meeting must be given like any other meeting, or notice must be waived in writing. A quick point on that is we all know we have to give notice of a board meeting or a member meeting. But in certain situations where there's not time to give notice, you can have all the board members or all the members sign a waiver of that notice requirement. And at that meeting, all members must be able to communicate with each other and to vote. You must have a quorum attending the meeting. And let me talk about quorum for a second. For a director meeting, a quorum means a majority, but the members have the right to change that from majority to more than a majority. They could require like 2/3 or 75%, or all of the directors have to be present to be a quorum, or they could reduce the quorum requirement, but it can't be reduced lower than 1/3 of the directors. For a member meeting, again, the law says a majority of members is a quorum at a meeting, but the law also says the members can change the quorum requirement. They can raise it as high as they want, and they can lower it as low as they want. It's not restricted to 1/3 like the directors are. So theoretically, you could reduce the member quorum to 1 member. I mean, I'm being a little facetious there, but there's no limit on how low you want to make that. But well, that's a good thing for membership associations, because they can't always get a majority of members to respond or come to meetings. At the same time, it could be sort of dangerous if you put that quorum too low. For instance, if you've got 100 members in your nonprofit, ordinarily a quorum would be 51. If you lower the quorum to something like 20, then 11 members would be able to take action for the whole organization. So for a 100-member organization, 11 members could amend bylaws, amend articles, and take any other member action. So it's flexible, which is good, but you have to be careful with it. Now, how voting is conducted at a remote meeting isn't really addressed by Michigan law. But what I generally see by voting at a remote meeting is it's done by voice vote, which means the chair says, okay, all in favor say aye, all opposed say no. It's done by polling the members, in which every member is called out. How do you vote? It can be done by raising of hands. If it's at a video meeting, it can be done by raising of hands to count the votes, or it can be done by electric transmission from a meeting. So if you're at a validly called member meeting and it's time to vote, each member could electronically transmit their vote into the organization. Although the law doesn't specifically say that, it can be done by, I'm going to go out on a limb and say that can be done by email, or it can be done by text. Any type of electronic transmission where the organization can keep a record of the voting would be allowed. Any action at a remote meeting must be approved by a majority of the votes cast, unless a higher amount is sent by the bylaws or articles. So ordinarily, it's a majority of votes, unless you want a higher requirement than a majority. Proxies can also be used at member meetings. Proxies are good ways to get members to participate or to meet the quorum requirement. Proxies, a member just has to sign the proxy, fax it back in, and that helps go towards the quorum requirement. Any action? Yeah, go ahead.
This is Melissa. I'm sorry. We have a couple of questions. So
Yeah, go ahead.
the first question is, do all members need to vote to override the annual meeting in person requirement, or can just a majority of the members of the association agree to have a remote meeting?
No, that's really a board decision on whether they want to have a remote meeting or not. That's a board management decision. So the board can actually call a member meeting when everyone has to come in person, or they can say, we're going to do a remote meeting.
Okay, and then if your bylaws require in-person voting at an annual meeting, but are otherwise silent on having a virtual annual meeting, do they just need to have the virtual annual meeting without voting?
Okay, did you say there the bylaws say you have to have an in-person meeting?
You have to have in-person voting.
Okay, if the bylaws require you have to have in-person voting, then you have to have an in-person meeting, unless the bylaws are changed.
So they could just have, but could they have just an informational meeting remotely?
Oh, yes, of course. Yeah, they could do that. Yeah, they could have informational meeting, but if your bylaws require in-person, then you've got to have in-person voting, or they have to change the bylaws.
Okay, thank you.
Okay. Okay, and then Michigan law also provides that any action taken at a meeting that was not, well, that's at an invalid meeting, should I say, that was not properly noticed, or there wasn't a quorum, or voting wasn't done properly, any action taken there has no legal effect and can be challenged by a member or by a director or by the Attorney General's office. Also, any action taken at a meeting that you realize later that maybe you haven't followed all the procedural rules can later be ratified by the board or by the members. So if you had a board meeting or a member meeting and you think that maybe, or somebody's questioning what happened there, maybe it wasn't properly noticed or something wasn't done properly, you could, at the next meeting, you could ratify what was done at that prior meeting, and that would correct any problems with the first meeting. All right. So that was all about how to do a remote meeting. Now I want to talk about how to take member or direction action without a meeting. So first of all, director action. Michigan law allows directors to take action without a meeting if all the directors sign a consent without a meeting, unless the bylaws or the articles or your policies prohibit it. So if you can get every director to sign a consent of a meeting, that's a valid act. You don't have to give notice. You don't have to worry about quorum or anything, but you have to have every director to sign that consent form. Okay, other than that unanimous written consent form, directors have to hold a meeting in person or by remote electronic communication. I should also mention there that directors cannot give a proxy to another director in a membership organization. That's something I run into a lot, where organizations are doing that, or they're asking me if they can do it. And no, that is prohibited by Michigan law. Directors cannot give a proxy at a membership organization. But in a directorship organization, which is a nonprofit that does not have members, has directors only, a director can give a proxy for the sole purpose of voting for directors. Okay, now how can members take action without a meeting? Members can take action by what we call ballot vote if the organization has put in their articles or their bylaws that ballot voting is allowed by the organization. Ballot voting must comply with the requirements of the Michigan Nonprofit Corporation Act, which really aren't too onerous. Essentially, the requirements are the ballot has to set forth the proposed action to be taken. It has to provide for a vote, like check the box on who you want to vote for. And then ballot has to be returned, and the ballot has to say how many days does that ballot have to be returned, and it can't be less than 20 days or more than 90 days. So if the organization receives ballots that exceed the quorum requirement, that's a valid meeting. So I strongly recommend membership organizations to adopt ballot voting. It's really a modern way to operate, and some organizations were sort of doing it anyway, but it wasn't really allowed by Michigan law, but now it is. So I recommend that you look seriously at amending your articles or bylaws to allow for ballot voting by members. And then members can also act by unanimous consent if you can get every member to sign a unanimous consent, which is pretty difficult for most organizations because they've got a lot of members. Or if you have amended your articles or your bylaws to provide for a majority of the members to act by written consent, you can act by consent of the majority of members. Okay, so those are ways that organizations can act without a meeting and can be very helpful to operation of nonprofit corporations.
I have a couple other questions. This is
Yeah,
Melissa.
go ahead.
One is, if your documents force an in-person meeting, could you conduct it outside?
When you say outside, what do you mean outside?
An outdoor gathering?
Yes, you could conduct an outdoor gathering, yeah. Mhm.
You just need to follow the no more than, I believe right now it's 100 people rule outside.
You mean the CDC rule?
I believe it's in the June 1st executive order of the governor.
Yeah, you got to satisfy the CDC rule and the governor's executive order, yes. But yeah, you could hold it outside or you could hold it indoors. Yes.
And then someone else would like to know, what's the specific criteria to know when the COVID guidelines expire?
I mean, is that I'm not sure what that, relates to, which topic. But I mean, the executive order of the governor, I would think, addresses that and says, we got to follow social distancing, and for how long, I would think that that's there. And, that refers to the CDC guidelines. So I think it's up to the governor when those things expire. Would you guys agree?
Yeah, they don't have an expiration date at this time, so they'll continue until the governor changes or issues when they terminate. Yeah.
And I believe that the CDC would have to walk back their guidelines for those to be expired. So until they back them down, then you are bound by them. So someone else's question is, you've said before you can't vote by email on action of the board, even if it's unanimous. So is that action without a meeting by a board to be voted upon by ballot?
Ballot voting is for members only. Directors can't vote by ballot. Directors can only act by unanimous written consent or by having a meeting in person or electronically at which proper notice was given and a quorum is at the meeting.
Right, but
So
yeah.
I think what she's saying is, if you vote by email, how can you make that a valid action if the board votes by email?
Okay, board can't vote by email. Board can only act by unanimous written consent or by holding a meeting. Members can act by ballot, but board cannot. Board's got to have unanimous written consent or they've got to have a meeting.
Well, I think what we would say is, for the condo and HOA context, if you have electronic transmission, if something is required to be in writing and it's transmitted electronically, then that would be a valid consent, right?
Yeah, you're saying, can they vote by electronic transmission to a unanimous written consent? Is that what you mean? Yes, they can do that. Yeah.
Because that's what a lot of our clients, I always tell them, technically you can't vote, you can't do board meetings by email, even though everybody does. And it's gotta be unanimous if you're gonna do an email consent. They don't like that. A lot of them don't believe in that or don't follow it, but that's what the law is. And I would say you take those written consents and you attach them to your minutes for your next board meeting, so there's a record of what was done by unanimous consent.
Yeah, that email can be a written consent.
Right.
And so I think that would still meet this requirement of the law. But you got to have every director send in their consent electronically.
Right.
But then you can ratify it at your next meeting.
Yes.
You can do that too, yeah.
Yeah, you could ratify at the next meeting. That's a good point. Yeah. We've got a question there by Jasper, Melissa. Did you see that?
Yep, it just popped in. So they want to know, He wants to say, to be clear, you can have a board meeting by Zoom or teleconference, correct?
Yes, that's automatic unless your bylaws or articles prohibit it. All right. And the last question I want to get into is one that was already addressed partially by Greg, and that was, can our organization be liable if someone contracts COVID-19 at one of our meetings or in the workplace? And as Greg said, yes, the answer to that is yes. And really the question is, did the employer meet the standard of care that an employer is supposed to meet? And the best way to meet the standard of care is to follow the CDC guidelines or the governor's executive orders. MIOSHA also has a whole new website on workplace safety. So you should follow MIOSHA, governor executive orders, and CDC guidelines in the workplace. And then the question will come down to, was the employer negligent? Or did the employer meet the standard of care that they were supposed to meet? And then the other question is, can they prove it? Greg already hit that, difficult to prove. But it is an area of law that's evolving. It's just become an issue. I think we're going to see a lot more cases about this. And so this is all, will all start to be flushed out in the near future. And that concludes it. We have time for questions if anyone else has questions.
Thanks. I had a question for you, for the two Eds. You talked about doing your annual meetings or membership meeting by means of remote communication. Have either of you actually seen or heard of any membership meetings being done by means of remote communication or electronic transmission, especially now?
I'm not aware of any, Greg. And to that point, I've heard an awful lot of questions about that. Associations are exploring that possibility. And to that end, there are third parties out there that sell their services to facilitate your ability to have people participate in meetings by remote communication, whether it's electronic casting of ballots or just simultaneous communication. So I'm aware that those kind of procedures are out there. I have not seen anybody use it though.
Yeah, I would agree with that. Annual member meeting has always been done in person. It was as much of a social event as it was of an annual business meeting, but we can't do that this year. So more and more folks are looking at doing that electronically.
Okay.
Okay, so questions for Greg regarding the clubhouse. Should people not be opening their clubhouse and doing rentals at this time?
I have the same concerns about amenities in general. If they were closed, you might want to keep them closed. If you open them, you need to be very careful, understanding that, again, there may be no insurance coverage if something bad happens. If you get sued, if you have a clubhouse that is frequented by many, many members, then I think that's a higher risk, and you're taking a chance. If you're going to keep the pool closed, why would you open something else that would have the same effect of people? If you know there's a high risk of people gathering there on a regular basis. And if you do open it, I think you need to have a comprehensive strategy of, number one, having waivers, number two, posting warnings, number three, have a plan of action that's similar to what the counties are having about their pools. Have a plan of action as to how you're going to comply with the requirements to clean the surfaces, cleaning frequently contacted surfaces, all that other jazz. You need professionals to do that. You need to have a plan in place to show that you're doing it. So I think the same concerns are present, and nobody's saying that people get COVID through the water, right? It's not the pool water you're getting the contagion from. It's the gathering of people in a small place like that. usually with just swimming clothes on, right? There's furniture around that ton of different people use. So maybe a pool scenario is a little higher risk than a clubhouse that is used or rented on a less regular basis. The risk may not be the same. But I just keep going back to liability. Are you willing, do you have the money to defend yourself if you do get sued? I mean, somebody mentioned in the chat, have we seen a lawsuit yet? No, we haven't seen, I haven't seen one yet. I'm sure they're coming. So I'm sure you're going to see lawsuits related to COVID as well as related to insurance issues related to COVID. So when insurance companies say, we don't want to cover this because it's excluded by a pandemic clause, then you're going to have people fighting over that. So this is, again, uncharted territory for all. And you need to make the best decision you can for your community. Best decision could be we don't open in 2020. We keep those facilities closed. I think that's a legitimate decision. People will be upset. Not saying they won't be, but you're kind of in a tough place. It's a no-win scenario with risks on either side. What do you guys think about that, Ed? I'll throw that to you guys.
Yeah, that is a tough decision. The conservative and safest thing to do is to not open the pool.
Yeah.
Otherwise, you're taking the risk of an expensive lawsuit without insurance coverage.
Ed Z.
Okay. Question, real quick question. Do the COVID exclusions for coverage that apply to pools also apply to if you guys held if an annual meeting is held and someone says they got COVID at your annual meeting?
An interesting question. You have a duty to hold an annual meeting, and you don't have a duty to open the swimming pool. So there, I think you're talking about a different set of circumstances. You would, however, need to be sure that you observe all objective criteria for holding that meeting. Not, making sure you don't exceed the number of participants that are allowed, making sure that social distancing is observed. And I would be concerned that if you hold a meeting and don't do those things, then you might be subject to a claim for negligence by someone who is infected.
Okay, and then can an adult sign a waiver to limit liability relating to an individual contracting COVID at the pool?
An adult can for themselves, right? As I said earlier, like you cannot sign a waiver to waive all of your child's claims. There's a case on that came out 10 years ago or so, said you cannot waive with a waiver like that a minor's rights. So, and I believe there's a statute on that too that says they have a year after they turn 18 to pursue a claim related to a tort, something like that. So you can't. That's one of the holes in the whole waiver idea, because if you got a bunch of kids using the pool or using the playground, the waivers are really they're worthless in the long run. You're gonna have that long tail liability. And the other hole I mentioned is the type of claim that's brought. Plaintiffs' lawyers will try to get around the waiver. They'll either say it's badly worded, it's ambiguous, it's not clear enough, you didn't expressly waive the negligence claim. Or they're going to say this was not just negligence, this was what they call gross negligence. Or even worse, it was willful or wanton misconduct. And those are two kind of higher thresholds to meet against somebody when they did something wrong. And the law says that you cannot get a waiver for that. Like they cannot protect, association cannot protect, the board cannot protect themselves for their own gross negligence. What's gross negligence? It's basically even worse than negligence. It's you acted with a substantial disregard to the risk of that your actions would cause injury to another person. So it's a higher standard for a plaintiff to prove that you acted with gross negligence. So it's not easy, but if they prove it, your waiver is worthless. So another hole for waivers. You can have waivers for negligence. If you want to say, we're going to demand everybody to waive any negligence claims they as adults could bring against the association for opening the pool. And if they got sick, yeah, that would in and of itself on the common law, I think that negligence waiver is enforceable. Assuming they can't poke a hole in the way it's worded. You know, they might say it's, as I said, not clear or not express enough. There's all case law on that, on the language of waivers and how clear they have to be enforceable. So it's not, and I've also heard of insurance people just saying, forget waivers completely. They're totally worthless. They're not worth the paper they're printed on. You know, I mean, you could have a waiver in hand. Does that stop somebody from filing a lawsuit against you? No, it doesn't. They can still sue you. Then you're going to defend and say this claim is barred by waiver, and you're going to try to file. You might try to get the case tossed right away. You might file a motion to toss the case right out of the gate, and maybe you'll win. And then maybe the case only costs you $5,000-$10,000 instead of $100,000 or $200,000 to defend. So again, the waiver doesn't protect you from just being sued, period.
Then a question is, if you post warning signs, doesn't that support the case against you for expected injury inclusion or exclusion? So if you post warning signs, are you saying, hey, you could be injured here and we would be liable?
I don't think so. The risk is there regardless. Even if you don't post the sign, they're going to say, what are you doing? You're reopening the pool. We just had another 200 cases of COVID. So I don't think there's any additional risk by posting a sign. The risk of COVID is there. It's undeniable. So I think you only gain by putting the sign up. When I've looked at case law dealing with signs and warnings, they say generally, yes, you should have some kind of a sign to put people on notice that this is a risky situation, and they are assuming the risk by putting themselves in that situation. So, you know, the BI exclusion is going to apply regardless, so it's already going to apply. So why not have the sign to at least try to protect yourself from those other types of claims, negligence claims?
And how could the board be committing a wrongful act if the county does an inspection and says that everything is good and the pool can be open?
Ed Z, you want to pipe in on that, or?
Yeah, a claim is going to look at the totality of the circumstances wherein the board made its decision. The board is charged with exercising reasonable business judgment in making all its decisions. And if you were going to file a suit and claim that the board did something wrong, you're going to try and show that the board did something that was unreasonable. Certainly one of the things that we are stressing is that the board's decisions need to be based upon objective factors. And so the board would say, well, the county said it was that we could open and we followed their guidelines. Therefore, we were not negligent. And it's actually a good argument that you would try and make, but it doesn't get you out of jail free if you are sued. They would still examine any other factors that might be available to show that somehow the board's decision was not correct. The opposite of that, however, would be if the board made a decision that was contrary to a published policy by the county in which the pool was located, then the argument would be that the board was negligent as a matter of law because it made a decision to act counter to government regulation. So yeah, that's something to keep in mind. I think, Greg, there was something else that I wanted to add too. The question came up that a pool's a common area like a lobby. Couldn't a resident hypothetically also sue the board alleging they caught COVID from a doorknob? And I suppose that would be true, but what I want to point out, the distinction between those two examples is that one is likely to be seen as an essential service in the community, whereas the opening of the pool is not an essential service. And so that distinction is going to be important For example, could you say all fire escapes are closed due to COVID until further notice? No, fire escapes are essential. And so, you know, you're going to have to leave those open. Doorknobs for common hallways, you know, yeah, those people have to use them to come in and out of the building. And so what's the duty of care with regard to those shared surfaces? You may need to take a look at your practices and be sure that those shared surfaces that are touched regularly but essential are being properly cleaned.
Okay, so if the policy has a bodily injury exclusion, then does that transfer as well to the workout room if somebody is using broken equipment, or if they somehow break their leg in the workout room? And what do you recommend boards do when they have those types of places?
Well, again, that's a little bit different. You're talking about something that I think would be covered by your liability, just general. If you got hurt on any facility, you're going to have, in any facility of the association, you're going to have your regular liability coverage would be in play. Now let's say if they get, that's different. If you break your leg or something, that's different. If we're talking about injuries that arise directly as a result, the end result of the board making a decision to reopen or not an amenity, the board controls that. The board of directors controls whether to reopen the pool. The board of directors controls whether to reopen the workout room. So yeah, I do think the same logic applies as to if it was a claim and you're asking whether you'd have D&O coverage for that. I think the same exclusion would apply. It's the same reasoning. You made a decision to reopen your workout room. You knew that you're going to have 100 people in there every day, or 50, or whatever size it is. You knew that, and you know, somebody contracted COVID as a result of that. So I think the result is the same as far as, you know, that exclusion is concerned.
And that workout room was not essential.
Right.
Not a fire escape.
Any other questions from anyone? Please don't forget, if you want to copy the presentation, you can drop your email to me in the chat box, to Melissa, and I will send out the presentation to you. If you are watching us on Facebook, you can comment to Stacia and she can send that to you as well.
Okay, anything else? Any other questions? I think we're out of time, so. Thanks everybody for attending. I hope you found it informative, and check back with us again in a month for our condo and HOA beats. We'll have more sessions like this.
Thank you, everybody.
Yes, thank you, everyone.